We're convening here at 6 p.m. on October 2nd, 2019, to consider an appeal filed by, looking for the correct name, Preservation Heritage. Perrysburg Heritage, from a decision by the Historic Landmarks Commission. My name is Tim McCarthy. For purpose of the record, I'm a member of the Perrysburg City Council, and I serve as chair of the Planning and Zoning Committee, and so I'll be chairing this meeting as well at the request of Council President Jim Matuzak. We'll proceed by having, I think I'll first ask Director of Law Laura Elkhire to identify what she's included in the written record that's been submitted to us tonight that I understand has been provided to applicant's counsel. So Laura, why don't you tell us again what you've provided to all of us up here in the dais, and also to the applicant and his attorney.
Yes, thank you. So we are here pursuant to an appeal of Perrysburg Codified Ordinance 124556, pursuant to what this council's review is on the appeal. I've provided to you in the first document, Historic Landmarks Commission meeting minutes, June 10th, 2019. The second document is Historic Landmarks Commission meeting minutes, August 12th, 2019. The third document is the appeal of the Historic Landmarks Commission decision on procedural grounds. This was filed by the applicant. I will state it was timely filed within 30 days of the June 10th meeting. Attached to that appeal is the application for the permit that went to the Historic Landmarks Commission. It's marked Exhibit A by the appellant. There are also several photographs and a survey drawing. There is also a meeting agenda marked Exhibit B. And some additional photographs and a print off of what looks like to be the Wood County Auditor's site showing the parcel number. And then finally, there's a correspondence from Zoning Inspector Cody Grodi that's dated August 26, 2019, addressed to Perrysburg Heritage LLC. Attorney Stephen Keller is here representing the appellant, and I did provide him with a packet, the same packet that council got. Council does also have at their place the Perrysburg Codified Ordinances, all the sections relating to the Historic Landmarks Commission. That would be sections 1245-45 through 1245-60. And I think just by way of procedural background, the Historic Landmarks Commission met and reviewed this application on June 10th, 2019, subsequently met on August 12th, 2019, rendered a decision. The Planning and Zoning Committee of City Council met on September 11th and agreed to consider those meetings as a total record with regards to this appeal, because the appeal was technically filed before the final decision was rendered by the Historic Landmarks Commission. So we are here, and it would be my advisement that you consider the entire record that's in front of you, including the June and the August meetings.
For the benefit of council, I'll refer you to something that Laura had sent us, in which she quoted section 1245.56 of our municipal code, and it says, in part, when considering appeal, City Council shall refer to the written guidelines adopted by the Commission and the entire record before the Commission. City Council may request additional information from the Commission and/or the applicant, and may hold a public hearing on the issue. City Council may affirm or reverse the Commission's decision. If City Council affirms the decision, the denial of the certificate will stand. If City Council reverses the decision of the Commission, it shall state as a matter of public record the reasons for the reversal. Two things. Obviously, we are here tonight to hold a public hearing on this appeal and on this issue. The record before the Commission consists of the minutes that have been provided by Director Butler or Elkire. And as we have done in the past, of course, the appellant, the applicant, appellant, whatever we want to call that moving party, should have the right to step forward and say whatever they'd like to say in support of the appeal and offer whatever information they care to offer. And I'm looking at you, Steve. We haven't met, but welcome. We're fairly informal here, but I'd give you this opportunity if you want to go ahead and explain the applicant's assertion as to why the Landmarks Commission decision should be reversed.
Certainly, and thank you for your time this evening, ladies and gentlemen. And thank you to the law director. I did receive the package that you received, and she'd also provided me with the video DVD recordings of these two meetings at issue. And we're here today on 401, and this is application 11-19. Let me begin by saying we're not here because we don't like a decision of the Historic Landmark Commission. That's not reason enough to say, I don't like the decision. There are specific reasons under your ordinance that you can appeal a decision. We're here because the commission did not do its job. It didn't. Under ordinance 1245.56 entitled Appeals, we can appeal for, quote, procedural errors by the commission, unquote. We have those. We can appeal for, quote, an incomplete explanation for the decision reached by the commission, unquote. We have those. We can appeal for, quote, where there's been a clear misapplication of the design review guidelines. We have those. So we have those three. Please keep those in mind, because if they exist, then this body needs to overturn the commission and grant the appropriate certificate. Accordingly, now comes Perrysburg Heritage LLC, an Ohio limited liability company, and the owner of 401 West Front Street, Perrysburg, Ohio, who respectfully appeals the Historic Landmarks Commission inaction and denial of the request for a certificate of appropriateness on reasons including but not limited to the following. So these are the sections that were violated. Section 1245.54F, failure to, quote, forthwith state in its records reasons for such determination. Violation of Code Section 1245.54F again. Failure of the Secretary of the Commission to, quote, notify the applicant of such determination and transmit to him or her a certified copy of the reasons for denial and recommendations, if any, of the Commission. Violation of Code Section 1245.49A14. Failure, quote, to review and act upon all applications for certificates of appropriateness. In violation of Code Section 1245.54D. Failure to comply with the requirement that if the proposal, quote, is determined to have no adverse effect on the historic district or listed property and does not violate the spirit and purpose of the preservation regulations, then the Commission Secretary shall issue the certificate of appropriateness. Those sections were not complied with by the Commission. Now we'll take a step back and go into the background. What's the role of the Historic Landmarks Commission, also known as the Commission or the HLC? That's under 1245.54, entitled Issuance of Certificates of Appropriateness. I'm going to read that. Quote, this is in paragraph A. Before any exterior change in design, texture, or material, or to exterior features, including construction, reconstruction, alteration, and demolition of any listed property, or of a property located within a historic district, can be undertaken, an applicant shall first apply for and secure a certificate of appropriateness from the Historic Landmarks Commission. The application for such certificate shall be submitted to the chair of the commission, together with such plans, specifications, and other material as the commission may from time to time prescribe. So in the present case, the property owner wanted a fence. It applied for a certificate of appropriateness. Note, this fence material, design, and layout have been approved at other properties, most particularly the exact precise neighboring property. Same material, same design, same fencing. Going back to 1245.54, the commission is concerned with design, texture, or material, not just disliking fences. That's not reason enough to deny an application. That's the role of the HLC. What are the standards for HLC approval? That's in 1245.54C. Quote, if the commission finds that there will be a change in exterior design, texture, or material, or to the exterior architectural features, the commission shall determine whether the proposed construction, reconstruction, alteration, or demolition is appropriate, or whether it has an adverse effect upon the purposes of this chapter and the historic district. Again, it's focused on, I'm quoting, exterior design, texture, and material. Those are the standards. Those are the rules. Fences are allowed. No one is saying that they're not. No one is saying that this fence violates any location. However, the only thing we haven't received is our certificate of appropriateness, which we properly applied for. Now, returning to the ordinance. And I quote again, in making such determination, the commission shall refer to the Secretary of the Interior's Standards of Rehabilitation. The Secretary of the Interior Standards of Rehabilitation. I've watched these meetings. These standards are not referred to in the meetings or in any statements thereafter. I don't even know, frankly, if the commission's read it. Those will be standards that we'll have to find out. And in fact, we'll find out if we're denied here and have to appeal to the Court of Common Pleas, which would be the next step. So what is the burden for the Historic Landmarks Commission? We probably have a lot of attorneys in the room. In criminal, it's beyond a reasonable doubt. The burden's on the state, the government, to score a touchdown, go to the field and score a touchdown. In a civil case, the burden is on the plaintiff by a preponderance of the evidence. Get the ball across the 50-yard line. Here, under your ordinance, 1245.54, D, if the proposed construction, reconstruction, alteration, or demolition does not violate these preservation regulations, then the commission secretary shall issue the certificate of appropriateness. So if the proposal does not violate the regulations, it shall be issued. Not because we don't like fences. This is important language. The burden is on the commission, not the applicant. Again, it's not being cited. The Secretary of the Interior Standards describe what should and shouldn't be done in historic districts. One member of the commission said the fence wouldn't look nice for tourists. Not a standard. One said she wouldn't allow this, but she would allow a chain link fence. That's not permitted under our ordinances and will be the front of the back property on this property. These are not comments related to material, design, or construction. These are not the Secretary of the Interior standards. It shows gross misapplication, stating I would approve a fence that isn't approvable, a chain link fence. That's a gross misapplication. Now let's discuss the facts and the timeline of this specific case. Perrysburg Heritage LLC owns various properties in the Perrysburg City Historic District. One of these properties is 401 West Front Street, Perrysburg, Ohio, the property at issue. Appellant previously applied for the Historic Landmarks Commission for approval of the same design, material, and construction of a fence on 407 West Front Street within the previous year. That application was approved. It's Exhibit A in your materials. The appellant then applied to the commission for the approval of a construction, design, material of a fence of the exact same on 401. At the June 2019 meeting, the commission met, and one matter on its agenda was our fence for 401 West Front Street. At said meeting, contrary to Code Section 1245.49814, the commission A, refused to vote yea or nay on the application, and B, stated as there was no vote, the application was denied. Accordingly, the appeal at hand was filed. I'm going to back up and address the issue the law director brought up, the statute of limitations in your ordinance. 1245.56 entitled Appeals. Quote, any such appeal shall be made within 30 days after the denial of the certificate. So why did we file when we filed? At the first HLC meeting, the June meeting as I call it, no vote was held. A motion to approve was made. The room went quiet. Watch the video. I hope everybody has. Watch the video. A member states at 32 minutes and 25 seconds, quote, from a parliamentary procedure standpoint, if there is no second, then we would just move on, and then the applicant would have the ability to go through the appeals process just like anybody else, quote. To which another member, the chair I believe, states, quote, I agree. And that's what they did. There was a motion to approve. There was no second. A member said, you're done. You can appeal, quote, just like anybody else. The chair said, I agree. And that's what we did. We appealed. That failure to vote is a violation of 1245.54 B, C, D, and E. Accordingly, in accordance with the direction of the commission, the appeal was filed timely, as the law director states, within the 30-day deadline. On August 9th, 2019, the law director and I touched base. She acknowledged the appeal was received and stated the HLC did not render a decision. That's a violation of 1245.54. They didn't render a decision. They have a duty to act. She instructed them to make a decision, and if the application was denied, she would, quote, immediately forward the appeal to City Council. It's another one of our faults with the first meeting. 1254.54F. If the HLC determines a certificate of appropriation not be issued, quote, the secretary shall notify the applicant of such determination and transmit to him or her a certified copy of the reasons for denial and recommendations, if any, of the commission. That wasn't done. We received no such certified statement. I'm going to come back to that ordinance in a little bit. That's been violated both times. Now I'm going to address the second meeting of the commission. The August 12th, 2019 meeting, or the second meeting, or the August meeting. The June-August meetings, however you want to refer to them. We object to that second meeting. Never even should have happened. They turned us down at the first one and said appeal, and we did. The matter was then before City Council. There's no authority for them to reconsider our application, which they attempted to do. They attempted to fix their wrong. So, again, watch that first meeting. And then, if you watch the June meeting, if you go back and look at the August 12th, 2019 meeting agenda, the August meeting agenda, I think it's in your packet from the law director, we're not even on the agenda. We're not even listed. 401 West Front Street's not even listed on the agenda when they went back and tried to fix it. Another procedural error where this body has to overturn the commission. Alternatively, if that August meeting was valid, it also violated your own City of Perrysburg ordinances. The HLC failed to consider the guidelines. Again, the Secretary of the Interior standards are in your ordinance. Those are the guidelines to use. Again, at one point in the second meeting, one said, I would approve a chain link fence. That isn't allowed under your ordinance. That's prohibited. Another stated the fence would keep children and people from wheelchairs from viewing the river. It's not relevant, although sympathetic, and not factually accurate. If you walk down that path, I could lay on the ground with my head on the ground and I can see straight ahead and see the river. This is a very steep property. The fence is at the bottom. You have to walk down to get where the fence is. Those are inaccurate statements. It shows they don't understand the property, they don't understand the ordinances, they don't understand our application, and they're telling us to get a chain link fence, which we can't get. It's prohibited under city ordinance. At that meeting, the second meeting, they aren't even sure who their secretary is. Why is that important that they don't know who their secretary is? 1254.54F. If the commission determines a certificate of appropriateness shall not be issued, quote, the secretary shall notify the applicant of such determination and transmit to him or her a certified copy of the reasons for denial and recommendations, if any, of the commission. You can't just send them the minutes. You can't just send them a letter. You need to send them, under your ordinance, the city's ordinance, a certified copy of the reasons for the denial from the secretary. That's very specific. I don't know if it's ever been done in Perrysburg history, frankly, but it's not being followed. Watch the meeting. Again, the commission doesn't know who the secretary is. At 45 minutes and 50 seconds into that meeting, one member says, quote, who is the secretary of the commission? Quote. What did we receive? We received, the law director handed it out, but I'll pass it out again here. It's marked Exhibit C. This is what we received in response to the second meeting. Letter of August 26, 2019, from Cody Grody, zoning inspector. The Perrysburg Planning and Zoning Division must inform you that the most recent Historic Landmarks Commission meeting, date, application 11/19, a motion was made to deny, which was seconded by Judy. The vote was 5 ayes, 1 nay, 1 abstention. The meeting minutes will be mailed to this address once they are approved. This Exhibit C in your hands, compared to 1254.54F, Secretary shall notify the applicant of such determination and transmit to him or her a certified copy of the reasons for denial. This is not a certified copy. Black's Law Dictionary, again, the lawyer's room, we know what a certified copy is. It's a copy of a document signed and certified as a true copy by the officer to whose custody the original is entrusted. This is a letter, a respectable letter from the zoning inspector. It's not from the secretary of the commission. The commission states we don't even know if we have a secretary. Another reason with the second meeting is the commission is shocked to find out they have to state a reason for the denial. One member states, I've been on here 2 or 3 years, we've never stated a reason for denial. Another member states the same thing. The zoning inspector has to read the commission the ordinance because of our appeal. The zoning inspector says there's an appeal, you need to start obeying the ordinances, and reads them the ordinance on the record. The commission states, well, our discussion is reason enough, to back up our evidence. That's not what your ordinance says. Certified copy from the secretary stating the reasons for the denial. Not stating from the zoning inspector, you lost 5-1. So what are reasons for appeal again? They all apply here. Ordinance 1245.46 entitled Appeals. Quote, procedural errors by the commission. We have failure to act at the first one. Failure to notify from the first and the second. Improperly reconsidering the first one at the second meeting. Failing to send certified notices by the secretary with reasons for denial. 2, these are the reasons, again, that under your ordinance. Quote, an incomplete explanation for the decision reached by the commission. That's the point of that certified statement by the secretary. Tell us why you turned us down. Public policy, I imagine, so we can fix it and do it again if we want to do it the right way. We don't have that. The first one, there's no letter sent. The second letter, we have a nice letter from the zoning inspector, but it's not by the secretary, it's not certified stating the reasons for the denial. 3, another reason for the denial under the appeal, 1245.46, quote, where there's been a clear misapplication of either the design review guidelines or the historic district ordinance. Blocking the view of the river, not true. One member states, and said it at the meeting in writing, it would make the area look like a ghetto. I don't know what that means. It has a very negative connotation, but it certainly is not in the Secretary of the Interior standards, making a neighborhood look like a ghetto. Suggesting a chain link fence, it's not allowed. There's no reference to the guidelines by the commission. There's no reference to any of the Secretary of the Interior standards. Again, our appeal, if we take it to the next level, is going to go through it. That's what we're appealing tonight, is what's been done to date, or frankly, what hasn't been done. So I'm going to go through the violation of the ordinances again. 1245.54F. The commission shall forthwith, meaning immediately, forthwith state in its records reasons for such determination. 1245.54F. That isn't done at either meeting. Violation of 1245.54F. Failure of, quote, the secretary of the commission shall notify the applicant of such determination and transmit to him or her a certified copy of the reasons for denial and recommendations, if any, of the commission. As I'm standing here, we haven't received that from either meeting. There isn't even a secretary of the commission as far as the commission's aware. Violation of code section 1245.49A14. Failure to, quote, review and act upon all applications for certificates of appropriateness. Going back to the first meeting, where there's a motion to approve, the room went quiet, and they said, according to parliamentary procedure, you're done, quote, you can appeal just like anybody else. And they said, I agree. So they failed to act. Either declined to act or failed to act. Both are violations. Both fail to have the proper procedure. And a violation of code section 1245.54D, failure to comply with the requirement that if the proposal, quote, is determined to have no adverse effect on the historic district or listed property and does not violate the preservation regulations, then the commission secretary shall issue the certificate of appropriateness. The burden is on them. Don't worry, I'm winding down, I promise. Now therefore, for reasons included but not limited to the foregoing, pursuant to your ordinance 1245.56 entitled Appeals, appellant appeals to City Council to reverse and overturn the commission pursuant to 1245.56 procedural errors, the voting issues, failure to provide a certified denial with reasons by the secretary. 1245.56, quote, an incomplete explanation for the decision. 1245.56, clear misapplication of either the design review guidelines or the historic district ordinance. I thank you for your time. I open myself up to questions, if there are questions.
Thank you, Steve.
Thank you.
Does anyone have any questions for Steve?
I have just one.
Yes.
You brought with you as an exhibit the Secretary of Interior guidelines.
Yeah, oh, I haven't admitted it as an exhibit, but yeah, I mean, I've got some exhibits. But yes, I did hold them up, yes.
You brought it as a prop.
Yes, yes. Well, no, I can make copies. It's a thick,
I don't need a copy.
your ordinance states the website where they're obtainable.
Wait for my question, okay?
I apologize. Please proceed.
You appealed based on these 4 different violations. Which one specifically, which one of these 4 violations does that one relate to?
1245.49A14, 1245.54D.
Can you explain to me how it fits into A14?
Yeah.
Because it just says to review and act upon all applications for certificates of appropriateness.
Because it ties into 1245.54D and the others. To review it, you have to apply those guidelines.
I'm not trying to challenge it.
Oh, no, I understand the question. But I'm saying, that one states you have to review it. The other one says when you review it, you have to apply the guidelines. That's how they're
So
connected.
to review it, it's your interpretation that to review it, you have to do that.
Right, Right.
That's your interpretation, right?
it is.
Okay. And then in violation code section 1245.54D, you said it fits there because that does not violate the spirit and purpose of the preservation regulations. And you're interpreting the preservation regulations to be the interior.
I am.
And
If you give me 1 second,
in both those cases,
I'll read the ordinance if you have a second.
that's fine, but in both those cases, I just want to understand how it is that you reached the conclusion that those guidelines are what the commission needs.
Absolutely. It's a very fair question.
It doesn't specifically say that.
It does, respectfully.
Okay.
1245.51 entitled Guidelines for Reviewing Applications Rehabilitation Standards. Paragraph B, and I'm going to read these. The quote, "The following guidelines are designed to help individual property owners formulate plans for the rehabilitation, preservation, and continued use of historic buildings consistent with the intent of the Secretary of the Interior's Standards of Rehabilitations." I'll come back to that. Paragraph B2, specific information on rehabilitation and preservation technology may be obtained by writing, a little outdated, but writing to the Technical Preservation Services Division, National Park Service, U.S. Department of the Interior, then it has a website, or to the appropriate state historic preservation officer. Let me give me 1 more second here too. If we go to, this is ordinance now, 1245.49, paragraph 15, I'm going to read verbatim. To use the Secretary of the Interior's, quote, standards for rehabilitation, quote, as set forth on the Secretary of the Interior's website. There's a web address I won't read. That's in the ordinance.
So I was trying to listen and not read along.
Oh, that's all right, I understand.
So based on what you just read to me, is it your position then that rather than those guidelines being used as examples or suggestions of things to help you, rather you're actually required to use those?
I'm going to read the language again. To use the Secretary of the Interior Standards for Rehabilitation as set forth on the Secretary of the Interior's website.
I guess I'm gonna have to read it because it's not a complete sentence. It starts with.
Oh, no, I trailed off. Go ahead. You're on.
So what put that in context?
Yeah, what ordinance are you in? Do you have the ordinance in front of you?
So 15.
1245.49, paragraph 15.
Okay, so 15. I just want to see something.
Sure.
Again, I'm not trying to.
No, that's all right. Take your
I'm trying to
time.
prove it.
If I'm mistaken,
Trying to- Okay. The duties of the Perrysburg Historic Landmarks Commission are as follows. To use the Secretary of Interior standards for review as set forth in the Secretary of Interior's website.
which section are you in now? I'm sorry.
I'm the one you gave me. I just wanted to.
You're in 4.9 or 5.1?
445.49.
Okay.
A 15. You were reading me just 15.
Right, right.
I needed the first 2 parts.
Absolutely,
I
absolutely.
understand why I
Yeah.
So the commission is required to, under 1245.49, as one of their duties, are as follows: to use the Secretary of Interior standards for rehabilitation as set forth in the Secretary of the Interior's website. How do you, I'm not trying to be
It's all right.
funny, but how do you know they didn't use them just because you didn't see them and they didn't make reference to them?
I don't, but I have watched if you watch the transcripts. But I don't know what they were thinking, no. But they certainly weren't stated in any reason up for denial. Yeah, sorry, yeah, I don't know what they were thinking.
I'm
I don't
saying I
know.
can use home sections that I'm familiar with without having to refer to them,
Mhm.
because that's how I base my thinking.
Mhm.
And so I'm just, so it's your claim that they didn't use it because you're not aware that they used it.
The record, we're appealing, all we can appeal is the record. If they thought something and didn't say it, we can't appeal their thoughts. We will appeal the transcript of those proceedings.
I just, okay, I appreciate it.
Thank you.
Anything further?
Yeah, so in that same section, number 15, where it says to use the Secretary of Interior standard for rehabilitation, as set forth on the Secretary of Interior's website, and any other written guidelines that the commission may adopt. I believe in one of those proceedings, one of the members, I believe it was Ms. Edinger, quoted from another guideline that the commission uses.
Yeah, she looks at page 193, I believe.
Did it discourage solid fences?
She does not state that on the record that I recall.
All right, I'm just going on memory. I don't have that transcript or anything.
My recollection is she stated part of their duty was to beautify or preserve. She did not state anything specific on fences that I recall.
I know she quoted, she read from a section about fences in there, and I remember, only because I was present at the time, that,
Sure.
and I wish I had that book in front of me. I don't know if zoning has a copy of that. Yeah, that book right there. That's what she was using. And you just bear with me a minute.
That's all right. I thought it was page 193.
It doesn't have that many pages.
Then it must not be.
139?
That would be it. That would explain my switch of the
Oh,
knowledge.
you just had, no. Why do I only go up to 105? No, it's not, this is not, no, she was using this book where it talks about fences, and if I could just bear with me, I'll find that, because I remember her giving a reason that, and using this guideline, which was designed specifically for Perrysburg, when the landmarks commission was organized. And is there an index here that talks about fences? Just bear with me a minute.
That's all right.
She was.
She referenced that same page both months.
Did she, and what'd she say, 130?
Up to 139 of the planning and zoning code.
That's planning and zoning code.
That's in the difference.
No, this is a guideline book, and this is,
That's in the August
This is
minutes.
the planning and zoning code.
Oh, is that where she-
39.
is that the book she went from then?
I don't know, but that's
Okay,
Planning
you
and
can
zoning.
find that.
According to,
Maybe I'm in the wrong
well,
book.
according to
potential
the,
witness in the audience, you can ask the question of a member of the commission. They
Okay.
have to be sworn in before they answer or be considered.
Do you have a question for Steve, Mark, or is this just discussion?
I have a question for Mark regarding this question. I guess my question is, why do you ask the question? Because I suspect if you're saying, well, she did refer to this because it says and any other written.
And any other, and that's why I'm asking, because this is a written
It
guideline.
doesn't say or any other written guidelines, it
Says
says and any other written guidelines. So I don't think that necessarily.
All right, but I was just trying to show that they were following a standard that they were,
something.
yes, they weren't just coming off the top of their head saying,
Okay.
you know, okay, so that's all right, then that's just the point I wanted.
All right.
All right.
But I know it's in one of these too, because she did cite it, and you probably saw that in the video where she was reading right from.
And she noted the minutes reflect the June 10th, 2019 minutes. On the law director shared those materials. On our application, 1119, those last three sentences. Ms. Ettinger noted the purposes of the commission and reference page 139. So when I watched that, my position is she noted the purpose of the commission, which is more of a general precatory purpose, not a specific requirement. That's my interpretation of her comments. On that record, which is, we're appealing that record, is what we're appealing.
Okay. It doesn't look like there's anything further for Attorney Keller, so we can let him sit down.
Thank you, gentlemen.
Thank you,
Ladies.
Steve. And Steve, I didn't ask you formally while you were at the podium, but I assume that's what you have to present in support of your appeal, or
That is.
anything to add?
No, I do not. Thank you for asking. That's our appeal.
Thank you.
Thank you.
Let's, the commission speaks through its minutes, but Patrice is here. If folks want to hear from her, I think it's kind of unfair to put her on the spot, but she showed up, so why don't you step up, Patrice? You have to be sworn and all that stuff.
It's not going to be that interesting.
Ma'am, would you raise your right hand, please, to be sworn? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Patrice Spitzer, 315 East Front Street, and I'm on Landmarks. And I was not at the meeting in June. And so when, I don't know if Mrs. Ettinger read that in June, because I was not there. She did in August. And I don't think it was exactly just about fences. I think it was more general about the care of Perrysburg and the district. So that's just what I had to say.
Let me ask you something, Patrice. The minutes make reference to section 1245.46, which is the declaration of the public policy and purpose of the Historic District Ordinance. And you were at the August 12th meeting, correct? The
Yes.
second meeting. And reference was made to this ordinance. And I'll just ask you some of these purposes, and I'll ask you in your opinion if that was a motivating factor in the commission's decision. One of the purposes is to maintain and enhance the distinctive character of historic buildings, sites, and areas in the city. Was that a factor that the commission, in your estimation, considered in saying this fence was not, did not enhance an area of the city, i.e. the riverfront?
I think so. Because I was not at the meeting in June, I was not fully educated, so to speak, on, and that's what is a problem here. But I think that, yes, I think it has to do with the Riverwalk, with people's view of the river. I think that it is, the walk is new. So older rules are not going to really address that or pertain to that. And I think it's not a trying to, I think it's people truly care, and we have a river walk, and it's in the historic district, and that's part of our feeling that people should be able to enjoy that.
There's another stated public service, which is protecting and enhancing attractions to residents, tourists, and visitors.
And I think that is what Mrs. Ettinger read. And so I think that was the basic feeling.
Where's that second one?
It's 1245.46. One of the stated public purposes is protecting and enhancing attractions to residents, tourists, and visitors. And if I check my minutes quickly,
It's referenced.
that's a provision, a particular provision that was identified in the minutes. The minutes also identify A4, which is improving the quality of life by enhancing the visual and aesthetic character, diversity, and interest of the city.
Right.
Again, was that in your
Yes.
mind a factor
Yes.
in the way that in the commission's decision?
Yes, that is all part of what Mrs. Ettinger read.
Okay.
So,
All right.
next question for that. Just so I understand what's going on right now. I think the beginning, is that right, you said,
I'm sorry.
Can't hear you.
I don't think
I
there's
had
anything.
40 minutes.
Oh, my.
No, I couldn't hear.
Yeah, you did.
I believe Ms. Alkire, when she spoke at the beginning of the meeting, she explained how the record is what the record is, and that's what we're considered. And I'm curious as to why we're asking somebody what the recollection of what they think the record might have been, and what bearing that has on anything.
That's a fair question, but my response would be, if I can find the section, the appeal ordinance that, it's right here. The appeal ordinance permits council to request additional information from the commission. And so long as Patrice was here, I just wanted to ask her for that additional information. And I didn't, my question was not, what did the minutes say? My question was, Patrice, as a member of the commission, was that particular provision in the code a factor in the decision the commission reached?
May I ask you a question?
Sure.
If those provisions are important, which I'm assuming they are important because Mr. McCarthy asked the question, if they were in fact important, why did you not have them included in the record as your reasons for denying that appeal?
I don't know. I don't know why they weren't included in the record. I thought that they were included in the record. I'm not taking notes.
If I may ask real quick, the meeting minutes are the record, am I correct in that?
That is correct.
So everything that she testified to is already in the record?
Is that it?
Because the way I understand, so I know that there was a question, sorry, just one clarification on the meeting minutes as well, is those meeting minutes which are completed by the commission is the actual response for the denial. From the way I understood it, that was what was talked about as in the meeting minutes, and that would be the response for the denial.
The meeting minutes are the record of what occurred at the meeting, and then our ordinances do proceed one step further, requiring the correspondence to the applicant, informing them of the denial. So I want to be cautious, just when I say the record of the denial would be included within the minutes, and then within the correspondence sent to the applicant.
Does anyone have anything further from Patrice? We didn't know you were going to be testifying.
No. No.
Thank you.
Okay.
I think that constitutes the record before us. As we all know, we're acting in a quasi-judicial capacity. We can adjourn to deliberate. That doesn't require a motion, but that would be my suggestion. There seems to be support for that idea.
I'll support that idea.
Okay.
I'll second that support.
All right. We'll stand adjourned at 6:45. Steve, we're off the record now. We'll talk about, and let you know this, if we're gonna make a decision tonight, or in some of these cases, we continue them to a second hearing, we'll try and let you know.
All right, thank you for the courtesy.
We have some direction. The council has deliberated, as we all know. We've been gone for about an hour or so. At this point, we have determined to take the matter under advisement. Council will then make a decision in a public session, and the applicant will be notified of the date of that session in advance. So Steve, you and John, you'll know what date we're gonna officially decide this. We're gonna try and do it as soon as possible. We don't know if we'll get it in October 15, but we're gonna try and move as quickly as we can. And as I indicated, once we settle on that date, we'll notify you.
Thank you.
With that, the record is closed. Thank you.